to you the Section 16 and 17 under the Republic Act 8792. Section 16, the formation and validity of electronic contracts. So, what are electronic contracts? Those are contracts which are not paper-based and electronic in nature. Generally, they are made for speedy entering into a contract for the convenience of the parties. So, according to Section 16, the formation of contracts may be expressed in, demonstrated, and proved by means of electronic data messages or electronic documents, and no contract shall be denied validity or enforceability on the sole ground that is in the form of an electronic data message or electronic document. So, let us proceed in paragraph 2. It talks about the electronic transactions. So those are transactions in the sale of goods or purchase of services over computer-mediated networks. So according to Section 16, electronic transactions made through networking among banks or linkages thereof with other entities or networks and vice versa shall be deemed consummated upon the actual dispensing of cash or the debit of one account and the corresponding credit to another. So provided that the obligation of one bank entity or person similarly situated to another arising therefrom shall be considered absolute or shall not be subjected to process of preference of credits. So let us proceed in Section 17. Recognition by parties of electronic data message or electronic document. So who are the parties involved in entering the electronic contract? So those persons are the originator and the addressee. The originator is the one who sent or transmit the electronic messages, while the addressee is the one who intended by the originator to receive the electronic data. So according to Section 17, in recognizing the electronic data message by the parties as between the originator and the addressee of an electronic data message, a declaration of will or other statement shall not be denied legal effect, validity, or enforceability solely on the ground that is in the form of an electronic data message or electronic document.
Next is the Section 18 of Republic Act 8792, or also known as the Ecommerce Act. So what are the circumstances that the electronic data message was truly or legally sent by the originator to the addressee? So here in paragraph 1 states that an electronic data message or electronic document is that of the originator if it was sent by the originator himself. In paragraph 2 states that it is deemed to be that of the originator if it was sent by a person who had the authority to act on behalf of the originator if with respect to that electronic data message or electronic document, or by an information system program by or on behalf of the originator to operate automatically. For example, if this is an email from the bank. So what are the instances that the addressee can assume that the electronic data message came from the originator? So the addressee will act on that assumption if the electronic data message or electronic document was that of the originator. The addressee properly applied a procedure previously agreed to by the originator for that purpose, or that electronic data message or electronic document as received by the addressee resulted from the actions of a person whose relationship with the originator. For example of this is when the originator gave his password to the authorized person to act on his behalf to send that data to the addressee. However, these are the instances that paragraph 3 will not apply when the addressee has both received notice from the originator that the electronic data message or electronic document is not that of the originator and has reasonable time to act accordingly, or at any time when the addressee knew or should have known had it exercised reasonable care or used any agreed procedure that the electronic data message or electronic document was not that of the originator. So that's all from my report. The paragraph 5 and 6 of this section will be discussed by the next reporter.
So to continue the discussion about section 18, when the addressee is entitled to regard the electronic data message or electronic document, and when the addressee is not so entitled. The addressee is entitled to regard the electronic data message or electronic document as received as being what the originator intended to send and to act on that assumption. The addressee is not so entitled when it knew or should have known had it exercised reasonable care or used any agreed procedure that the transmission resulted in any error in the electronic data message or electronic document as received. So next, what is the exception that the addressee will not consider the electronic data message or electronic documents to the extent that it duplicates another electronic data message or electronic document, and the addressee knew or should have known had it exercised reasonable care or used any agreed procedure that the electronic data message or electronic document was a duplicate. We have here the section 19, error on electronic data message or electronic document. So what do we mean when we say error? An error, it is a condition in which data on a digital medium has been altered erroneously. The error can manifest as several incorrect bits or even a single bit that is 0 when it should be 1 or vice versa. Addressee is entitled to regard the electronic data message or electronic document unless the addressee knew or should have known had the addressee exercised reasonable care or used the appropriate procedure. First, that the transmission resulted in any error therein or in the electronic document when the electronic data message or electronic document enters the designated information system, or the electronic data message or electronic document is sent to an information system which is not so designated by the addressee for the purposes. Example, the teacher is the addressee and the student is the addressor. The student will pass his or her assignment to the teacher via Facebook chat, and instead of writing the name of the teacher, another name of the teacher was used. Therefore, the addressee here or the teacher will not consider the electronic data message received because there was an error.
To proceed, we'll discuss about the Section 20 of RA 8792. So generally, the receiving party or the addressee shall not be obliged to acknowledge the receipt of electronic data messages or electronic documents unless the originator has requested for acknowledgement. Moreover, the addressee should send acknowledgement of receipt through a prescribed format as mentioned by the originator. So what if the originator did not provide a prescribed format? Then, in such cases, the rules that are mentioned in paragraph A shall apply, where the acknowledgement may be given by or through any communication by the addressee, automated or otherwise, or any conduct of the addressee sufficient to indicate to the originator that the electronic data message or electronic document has been received. Next, under paragraph B, the originator here has stipulated that the electronic data message or electronic documents shall be binding only upon the receipt of acknowledgement. Then, unless acknowledgement has been so received, the electronic data message or electronic documents shall be deemed as if it has never been sent by the originator. So, the question here is, what if the originator has not stated that the electronic data message or electronic document is conditional on receipt of acknowledgement, and the acknowledgement has not been received by the originator within a specified time? Then, in such instances, the rules that are mentioned in paragraph C shall apply, wherein the originator may give notice to the addressee stating that no acknowledgement has been received and specifying a reasonable time by which the acknowledgement must be received. And if the acknowledgement is not received within the time specified in subparagraph C, the originator may, upon notice to the addressee, treat the electronic data message or electronic document as though it has never been sent or exercise any other rights it may have. So that would be all for our report. Thank you for listening.